Okay, we'll call the meeting to order. The Standing Committee on Access to Information, Privacy and Ethics, meeting number 143. Pursuant to Standing Order 1083H7, the study of privacy of digital government services. Today we have with us Toronto Region Board of Trade Vice President Brian Kelsey. First of all, as most of the committee knows, there's been two motions brought before us. We'll start off with Mr. Kent. Go ahead.
Thank you, Chair. Well, colleagues, you'll recall a couple of weeks ago when I first brought a motion suggesting that we provide a safe and civil venue for witnesses to appear to discuss some of the unknowns and the so far unquotables with regards to the SNC-Lavalin corruption scandal. The Liberal Vice Chair, Mr. Erskine Smith, made it very clear that as he said, he's voiced and voted for a more public inquiry to get at the truth. And he said, I think everyone on this side, on the Liberal side, cares about getting to the truth. It's just a question about how best to do that. And we accepted with some disappointment Mr. Erskine Smith's characterization of the motion as premature, but he did make the point in saying that we should wait for the Justice Committee to make a decision on whether to reopen their inquiry or not, their study or not, and they didn't. He said, if necessary, he would be pleased to revisit the conversation, and that there was, Mr. Erskine Smith said, given that the waiver had been provided to the Justice Committee, that it was appropriate to hear more about this. And I'm hoping today that those on the Liberal side of this table will consider this motion, and I'll read the motion into the record. That given the new information on the matter of political interference in a criminal prosecution by the Office of the Prime Minister, disclosed in documents tabled by Jody Wilson-Raybould and Gerald Butts, the Committee A, instruct the Chair to write a letter to the Prime Minister requesting that he waives all constraints that may prevent individuals invited to appear before the Committee from speaking freely. B, invite Justin Trudeau to appear prior to April the 12th. C, invite Jody Wilson-Raybould to appear prior to April the 12th. D, invite Jane Philpott to appear prior to April 12th. E, invite Katie Telford to appear prior to April 12th. F, invite Elder Marcus to appear prior to April 12th. G, invite Mathieu Bouchard to appear prior to April 12th. H, invite Amy Archer to appear prior to April 12th. I, invite Ben Chin to appear prior to April 12th. J, invite Justin To to appear prior to April 12th. K, invite Jessica Prince to appear prior to April 12th. And L, to sit extra hours in order to conduct these additional meetings. Monsieur Gourde, en français, s'il vous plaît.
Oui, ça me fait un plaisir.
I would gladly repeat the motion in French. That given the new information on the matter of political interference in a criminal prosecution by the Office of the Prime Minister disclosed in documents tabled by Jody Wilson-Raybould and Gerald Butts, the committee A, instruct the Chair to write a letter to the Prime Minister requesting that he waive all constraints that may prevent individuals invited to appear before the committee from speaking freely. B, invite Justin Trudeau to appear prior to April 12th. C, invite Jody Wilson-Raybould to appear prior to April 12th. D, invite Jane Philpott to appear prior to April 12th. E, invite Katie Telford to appear prior to April 12th. F, invite Elder Marcus to appear prior to April 12th. G, invite Matthew Bouchard to appear prior to April 12th. H, invite Amy Archer to appear prior to April 12th. I, invite Ben Chin to appear prior to April 12th. J, invite Justin To to appear prior to April 12th. K, invite Jessica Prince to appear prior to April 12th. And L, sit extra hours in order to conduct these additional meetings. Thank you, Mr. Chair. We hope that on the other side, they will be listening attentively to us, and we hope that light will be shed to the issue, and these witnesses will be given the opportunity to speak their minds, and so that everyone should know the truth about this very important issue, and that the issue will be quick. The sooner we resolve the issue, the better it's going to be for everyone.
Speakers list, so we have Mr. Angus. Go ahead, Mr. Angus.
Thank you. Well, I support my colleague on this issue because getting the facts on the record as to whether or not there was an orchestrated campaign to interfere in a criminal prosecution is the issue right now that's dominating our country. It's making it impossible for my colleagues in the Liberal government to move forward because we've not gotten clarity on this. This is a political crisis that is unprecedented. I've never seen anything like this, where we've lost the clerk of the Privy Council, we've lost the chief of the staff to the Prime Minister, we've lost two of the most respected women cabinet ministers, including the president of the Treasury Board, former Attorney General, the former parliamentary secretary to the Prime Minister. This is an issue that's not going away. Particularly, I note my colleague Mr. Erskine-Smith's comments I read in the Toronto Star, but also at the last committee, that he felt this was being handled by the Justice Committee. Well, the Justice Committee shut this down, did not allow further testimony. The only two key people from the Prime Minister's office who testified both had to quit their jobs in disgrace. So there are unanswered questions. There are questions about who in the office overstepped their ethical obligations. I also note that my colleague Mr. Erskine-Smith said if there was new evidence to come forward, then it would be definitely within the purviews of the Ethics Committee. Well, I certainly would suggest that after hearing the testimony, the information brought forward by Ms. Wilson-Raybould, that everything that she said at that Justice Committee has been verified by her facts, and none of those facts have been contradicted by any other evidence. I also note that Mr. Butt's counter evidence does not create a pattern or an image that these people were personal loggerheads, that there was this conflict, that she was impossible to work with. I found that there was a great deal of respect because she felt that she was working for the Prime Minister's interest. Her conversations and the text messages that Mr. Butts provided were very respectful. It was about whether or not there was interference in the rule of law. And that's what we need to stay focused on, not a larger soap opera, he said, she said. Was there interference in the rule of law? This is a fundamental question that has to be above party lines here. And I make that note as I received a letter this morning from Mr. Dago Koss of the OECD Anti-Bribery Unit, who wrote to me to confirm that they are paying very close attention. And they were paying very close attention because the government said that there would be a robust investigation at the Justice Committee, and that was shut down. Mr. Koss has stated that the OECD would welcome any more information to be handed because they are monitoring whether or not Canada has breached its international obligations. And if Canada breaches its international obligations in a matter as serious as an international corruption trial, it will certainly put us on the list of outliers. So it is well within the purview of the Ethics Committee because we have obligations to oversee the Conflict of Interest Act. We have obligations in terms of the obligations of public office holders that we have to deal with. There are issues of the pressure and the lobbying that went on into the Prime Minister's office that put key people in the Prime Minister's office, I think, in very compromised positions. So this is something that is within the purview of the Ethics Committee. I think we need to move on it. I think it's very unhelpful to have, the mano-mano back and forth between the Prime Minister and the head of the opposition as to who's going to sue who and who's, more willing to stand up to the other guy. That is not helpful. I think the simplest thing is let's get, and I don't care how long we sit, let's get the hearings done. Let's get a report. Let's restore it to the Canadian people so that we as a nation can decide if there was a problem, is there going to be accountability? If there wasn't a problem, then we can move on.
Thank you, Mr. Smith. Mr. Angus. Next up, Mr. Erskine-Smith.
So first, I have never been quoted with such approval from Mr. Kent and Mr. Angus. I encourage them, don't stop in the future. Although I do disagree with some comments Mr. Kent made earlier, referring to those of us on this side as minions. I have voted my conscience once or twice. I would also just note, I expressed skepticism a couple of weeks ago with respect to the ability of a committee like this to function as an investigatory body, and pointed to commissioners and their roles as more up to that task. I did say a couple of weeks ago that the motion then was premature, and I did so on the basis that I didn't want to predetermine what new evidence Ms. Wilson-Raybould was to put forward, and I am still of the view that had that evidence been new, had there been new allegations made that required another look, that it would have been open to our committee to undertake that. That's not what happened. Instead, there was a 43-page submission on the heels of 3.5 hours of testimony, and at the end of that 43-page submission, Ms. Wilson-Raybould wrote, "As such, for my part, I do not believe I have anything further to offer a formal process regarding this specific matter." I would also note that on April 4th, in the most recent Maclean's interview, Ms. Philpott noted, "I think there's enough information out there now for Canadians to judge what took place." So you have the two principal individuals who raised these concerns in the first place saying, "We've heard all that we need to hear." And certainly Ms. Wilson-Raybould in particular has said she's submitted everything that needs to be submitted. So for us to then undertake and renew this process all over again doesn't strike me as an effective use of our time. I would say, though, that with the Ethics Commissioner attending before us, or at least his office attending before us for the estimates, we should still be putting questions to the Ethics Commissioner as to this, whether that office has the tools, resources, and mandate to do this job effectively. Mr. Angus obviously noted the Conflict of Interest Act, and it is our purview, but typically we don't undertake these investigations ourselves as a committee. We ensure that the commissioner is doing the job that he needs to do, and that commissioner reports to this committee directly on those investigations.
Thank you, Mr. Erskine-Smith. We next up have Mr. Kent, and then we have Mr. Angus. Go ahead, Mr.
Thank you, Chair. Well, first of all, just a point of clarification. My reference to minions was quite clearly describing those in the Prime Minister's office who have exerted pressure, we know, in the Justice Committee, and we observe their considerable agitation and to and froing whenever the committee seems to be going in areas that they think they might concern.
Apologies.
It was not an apology. Your Liberal House leader pointed back and accused the Conservative benches and Conservative members of being minions, and that's what the Speaker was upset about. He wasn't, and I would suggest that someone convey to the House leader a check with the dictionary on the very honourable definition of what a minion is: a loyal, unswerving member of a staff who will do anything to protect their master. Now, with response to...
no one has ever accused me of that, by the way.
No, and I wouldn't suggest that a member should be... I don't suggest that any member of this House should be described as a minion. With regards to Mr. Erskine-Smith's response, we haven't heard from the one person in this entire continuing, and as I said today, ever-deepening scandal, and that is the Prime Minister himself. He has made the threat, and my colleague is a lawyer, and I think he recognizes a slap lawsuit as well as anybody else. It would attempt to be to shut down any criticism of any sort. We also haven't heard from those other names beside Ms. Wilson-Raybould and Ms. Philpott who have been implicated in wrongdoing and who haven't had a chance to speak to the truth or the accuracy of the testimony that we've heard from the clerk, from the former principal secretary, from Ms. Wilson-Raybould. And I was a little surprised to see her remarks that everything has been said that needs to be said for Canadians to make a judgment in this matter. But I think that there are still huge questions beyond that unprecedented waiver window, which the Prime Minister has referred to any number of times, and the period after, which led to her actual resignation from cabinet. Ms. Philpott, of course, had remarks with regards to and froing inside that window, and no one has ever heard testimony from Ms. Philpott about those events. So I would suggest that there is ample cause, ample reason to invite the Prime Minister first to remove all constraints on any of the potential witnesses listed, but to continue to look for the truth in this matter. And I think that there is still great uncertainty in any number of areas, on any number of issues, under the umbrella shadow that was cast by the very detailed and very credible evidence given by Ms. Philpott originally in the Justice Committee before their premature shutdown.
Thank you, Mr. Kent. Mr. Angus.
Thank you. Just to follow up with my colleague, Mr. Erskine-Smith, who I've never referred to as a minion. I think, may have referred to some members of the Justice Committee as you know, the PMO's house puppets, but I don't have such a good relationship with them as I have with my colleagues here, who I have enormous respect for. So we will maintain that respect. And I can't remember if I made that comment or not, but it wasn't about my colleagues here. But my issue here, there's a couple of issues. One is I wrote the letter to the Ethics Commissioner asking for him to investigate. And I wrote asking it under Section 7. Because the Ethics Commissioner has very few tools to deal with something of this nature. And we have to be very clear what the powers that the Ethics Commissioner has. So we had asked on the question of preferential treatment. That seemed to be an accurate reading. He came back and said, no, he felt it was Section 9. Now, Section 9 is on financial interest, which has always been ruled as personal financial interest. Nobody is suggesting that the Prime Minister has shares in SNC-Lavalin. That's ridiculous. So the decision by the Ethics Commissioner to go to Section 9, to me, has raised a number of questions about the study because he cannot deal with the issue that really matters to us, which is whether or not there is political interference in a prosecution. That's something he can't do. Secondly, he is off ill, and the Ethics Commissioner's office cannot release a report while he's off. Now we are told, well, the investigation's still ongoing, but that's not something in an issue of this manner. If he's the one dealing with it and he's off, that's problematic. I just want to say I was very surprised and thrown off to find that a cabinet minister's sister-in-law is the chief investigator for the Ethics Commission. Now, I totally expect and understand that this person recuses herself in this matter, but under the Conflict of Interest Act that defines family members for public office holders, she fits the definition. So it's, to me, I'm actually even questioning about formally requesting that they withdraw my request for an investigation because I don't have confidence he cannot deal with the matter at hand. As to my colleague, with all his many requests of who should appear, I mean, I've been here 15 years and we've dealt with all manner of smut and corruption, and we've never had a Prime Minister sit at a committee. So I was thinking, okay, well, I don't expect the Prime Minister to come for that. But as to whether or not Ms. Wilson-Raybould and Ms. Philpott have finished what they've had to say, that's not really the issue. The issue is that particularly Ms. Wilson-Raybould presented an enormous amount of evidence that we haven't got answers to. I don't know if we need to bring her back to get more evidence. She has laid out the evidence. You can't finish a trial or get to a conclusion unless that evidence is tested. So a number of people are named in that. Ben Chin. As a public office holder, she says that what he was doing was inappropriate. Was he flying free as a bird and trying to intervene, or was he directed by the finance minister's office? That's a question we need an answer to. Ms. Telford is quoted as saying she doesn't believe in legalities. Well, she's the right hand of the Prime Minister. Anybody who's that close to the Prime Minister has to put legality and the law at the top of the list. Was she misquoted? I think she should have a right to respond, but we need to know what her role. Mr. Marquez and Mr. Bouchard, what was really disturbing in the evidence that Ms. Wilson-Raybould came forward with and has never been contradicted by Mr. Wernick or Mr. Butts is this attempt to get around the Auditor General to see, or the Attorney General, to see if they could have a, off the record or just that they could talk to her. They actually didn't say off the record. But they talked about getting around to talk to her. That would be extremely inappropriate. So I think these witnesses need to be called. And then, so if my colleague wants to move forward, we could pare down the list a little bit and then say, so that we're not being repetitive, but we're focusing. And if those questions are unanswered, we could go to a larger list. I mean, that's how we tend to do things at committee. Let's start with a few. If we can get answers, then that makes, if the Liberals are happy, we'll move on.
Any further discussion of the motion table right now? Mr. Smith?
I'll just say something very briefly. I mean, I have discovered that Mr. LeBlanc has cousins everywhere. But
East of Rivière du Loup.
But with respect to the Ethics Commissioner and any questions that Mr. Angus might have, they're properly put to the Ethics Commissioner's office. And if his mandate is not sufficient, we should be putting those questions to the Ethics Commissioner. I said that the last time, it remains true. And the only other thing I will say is every single witness on this list could have availed themselves of the same opportunity that Mr. Butts did, which is to have requested to appear before the Justice Committee if they had something to say to contradict anything that Ms. Wilson-Raybould had put forward, and they could have submitted additional documents, just as Mr. Butts did at the very end of their study, accepted by that committee and published even though they had closed oral hearings. And anyone who wanted to contradict anything that Ms. Wilson-Raybould had said had every opportunity to do so. And so it does not make sense to me to say the two principal people in this who have raised these concerns have said they have nothing more to add. We have so much evidence such that we have a 17-minute recording of the key conversation in all of this for all Canadians to hear if they are so interested, and that we are, as a committee, which typically does not undertake investigations, we're now to invite Amy Archer to get to the bottom of this. I mean, frankly, if Amy Archer has something to contradict, she could have submitted it to the Justice Committee just as Mr. Butts did, and otherwise the evidence stands.
Okay, thank you. Next up, we have Mr. Kent and Mr. Angus.
Well, just in answer to that, Mr. Butts, of course, resigned in what I think many people saw as in disgrace before he brought that testimony. And I would think that even senior staffers in the Prime Minister's office or in the Finance Minister's office would be very prudent in avoiding any appearance before any committee, before making any public statements, given what they saw as the fate of the Principal Secretary, the Clerk of the Privy Council. I mean, two of the most senior individuals supporting the Prime Minister. So I think that they have not been given an opportunity. An invitation would certainly give them that opportunity. And it would, as I suggested, a letter from the chair would invite the Prime Minister to remove any constraints that there might be on those individuals to speak the truth here before, as I say, a civil and a safe venue.
Mr. Angus.
Well, I just have to think if what my honourable colleague said is clear, that if they had anything to contradict, they'd say it. I mean, Katie Telford is on the record, according to the witness, saying that she wasn't interested in legalities because they were going to get this thing done. That's a serious charge to make against someone who's the Prime Minister's advisor. If she's not interested in contradicting it, then I guess we have to accept that as true, that she wasn't interested in legalities. And if that's the case, she definitely needs to come before our committee, because as a public office holder, she has obligations to uphold. So I think it would be absolutely unacceptable that if Ms. Telford heard that testimony and isn't interested in contradicting it, because then we have to assume that it would be true, we have to bring her to committee to say, how can you function in the Prime Minister's office if issues of legality and interference in the rule of law are not something that's within the operating culture in that office? That, to me, is a question that now does need to be answered.
Back to Mr. Kent.
Well, and just one final comment. When this committee conducts studies, and we've done it with some collegiality over the past couple of years, we don't limit ourselves to testimony from only volunteers. As we saw with the Cambridge Analytica aggregate IQ scandal, we had to invoke the powers of this parliamentary standing committee to re-invite a number of individuals who we felt had misled committee and had misled Canadians with regards to the truth in those matters. So I don't think that in considering whether or not to strike this study, to ask the Prime Minister to remove all constraints, that we are going beyond the bounds of the normal practices of this committee. It is within our power in any study, and as my colleague Mr. Angus and Mr. Gourde have said, there are any number of unanswered questions still from the original testimony of not only Ms. Wilson-Raybould, but the clerk, the former clerk, and the former principal secretary, and allegations made about some of these individuals whose names have been somewhat possibly besmirched, that they may well have truths that they would like to speak under the protection of testimony in this committee.
So that's the last speaker I have on the list. Any further discussion on the motion? Guess we'll go to the vote. Recorded vote. Go ahead, Mr. Clerk.
Okay, the question is on the motion of Mr. Kent. Mr. Erskine-Smith.
No.
Mr. Stanning.
No.
Madame Fortier.
No.
Madame Nassif. Ms. Van de Belt.
No.
Monsieur Picard.
No.
Mr. Kent.
Yes.
Monsieur Gourde.
Oui.
Mr. Angus.
We,
So the motion is defeated, 6-3. So next up, we have the next motion, Mr. Angus.
yes, I would, I put people on notice on April 2nd on my motion that pursuant to Standing Order 108-3H6, and given the testimony provided by the former Attorney General of Canada, public office holders Katie Telford, Chief of Staff to the Prime Minister, and Ben Chin, Chief of Staff to the Minister of Finance, be invited before the committee to answer questions related to their conduct in inappropriately pressuring the former Attorney General and members of her staff in order to secure a deferred prosecution agreement for SNC-Lavalin. I think this motion is important, and it follows up on the work my colleague offered in the previous motion, but this is about the obligation that public office holders have to respect the rule of law. If we do not abide by that simple principle, then we are an outlier state, which is why the OECD right now is monitoring Canada. So the role of Katie Telford and Ben Chin have to be looked at, because the evidence, which my colleagues on the other side have clearly said, they're not contradicting any of the evidence Ms. Wilson-Raybould said. Her evidence stands, and her evidence is that Ben Chin inappropriately approached her staff and attempted to pressure on behalf of SNC-Lavalin to interfere with a public prosecution, and was told that that was unacceptable interference, which it is under how our legal system is structured. So the question we have to ask, was Mr. Morneau inappropriately pressuring? And the evidence, which my colleagues in the Liberals seem to, they're willing to accept Ms. Wilson-Raybould's testimony that she told the finance minister to back off, that this was inappropriate, and that this would certainly be a violation of the law. So the question on Ben Chin is, what was his obligation to his minister? To advise him on the obligations that he has to meet the rule of law, to respect the rule of law, to know that he has no right to interfere with the Attorney General in attempting to interfere in this prosecution of a bribery case against SNC-Lavalin. So Mr. Chin needs to be called here. Not voluntarily to say, well, if he has anything to contradict, it's to ask him about whether or not he respects the code that he has been called to uphold. The same questions need to be applied to Ms. Katie Telford, who the testimony we have received, which my colleagues on the Liberal side say has not been challenged, is that in her pressure to Ms. Wilson-Raybould's office, she said they were not interested in legalities. That is a shocking statement to make. If the Prime Minister's chief advisor is not interested in whether or not they're breaking the law, then we are lawless. Was she doing that because the Prime Minister didn't care about the rule of law? Well, we do not have the power at committee to bring the Prime Minister. But we had Mr. Butts come. Mr. Butts was forced to resign. And Mr. Butts was forced to resign. He said, well, because he wanted to do a whole bunch of other things in life. But he was unable to contradict the testimony of Ms. Wilson-Raybould, where she said that Mr. Butts told her there was no way they were going to get through this without interference. And interference is interfering in the role of the public prosecution. So Ms. Telford has not come forward. Seemingly, if we take the argument of my colleagues on the Liberal side, there is no contesting from Ms. Telford or whether or not that she said that. They don't seem to be contesting that she said she wasn't interested in legality. So she, as a public office holder, has legal obligations to uphold. And we, as a committee that oversees ethics and accountability in Parliament, must ask the Prime Minister's Chief of Staff to come and explain herself. Is there an outside chance she was misquoted, or does the issue of the rule of law not matter in the Prime Minister's office?
Thank you, Mr. Angus. Mr. Kent?
Well, I fully support my colleague in all that he has said and that has been said in support of my previous motion. So with a scaled-down motion and with, I think, fairly powerful arguments, we have no hesitation on the Conservative side in supporting the NDP motion.
Okay. Any further discussion with the motion before us? Seeing no further discussion,
Sorry,
go ahead, Mr. Angus.
just give me a second. I'm on a BlackBerry. It's sometimes slow. But I do still think that, I mean, we did not draw.
I can give you some time to think. I'm just going to talk to the witness just to explain
Okay.
a few things while you
Thank you.
think a bit. So again, Mr. Kelsey, we are going to get to you still today. We do have time. Appreciate your patience, and we do have committee business as well, but I think we have time for everything. We had one witness that said they weren't able to make it today, so that's fine. We did try and reschedule, but that person isn't available Thursday either, and we'll get into that a little bit later, but just to let you know, rest assured, we are still going to hear from you today. Mr. Angus, you ready?
Yeah, I was going to read the quote from Ms. Philpott, but I wasn't unable to bring it up. But I think I've seen many scandals in my 15 years. I've seen people doing dumb things. I've seen people getting caught for taking money. I've seen people, mostly men, almost all men, doing dumb things sexually that they shouldn't have done. I've never seen, ever, two people resign from the highest positions that you could imagine in the country because they said it was an issue of integrity. And I was very struck by Minister Philpott, who had no need to give up her career on this, who carries enormous weight in the communities I represent, I must say, in the work that she did up in Treaty 9, and that she said that there are things that are bigger than your political career. It's about ethics, she said. It's about constitution. It's about integrity. And I think that after this scandal is all said and done, people will remember those statements and say that it is possible within the Canadian parliamentary system to do things with integrity, but sometimes it takes a cost. And in the case of Ms. Wilson-Raybould, she clearly did not have animosity with the Prime Minister's office. She respected them, but she was willing to give that up. In the case of Ms. Philpott, she gave up President of the Treasury Board, which is an extremely high honor, in order to say it's a larger principle of the rule of law. So I appeal to my colleagues that this is about integrity, and it's hard. And it's hard when it's your party that's in the vice grip, and you are extremely loyal. Your party gets you elected. That's your number one obligation, is that the party got you elected. But what you carry from that point on is your integrity. And I've seen people give up their integrity because they think they're being loyal to their party, but at the end of the day, what you carry through Parliament and you carry through your career is that integrity. That's what you trade on. That's what gets you out of trouble if you make mistakes. And I would appeal to my colleagues, based on the very clear call of Ms. Philpott, that we do this and we do it right.
Thank you again, Mr. Angus. Any further discussion on the motion before us? We'll go to a vote.
Recorded?
Recorded vote. Mr. Angus, go ahead, Mr. Clerk.
Mr. Erskine-Smith?
No.
Mr. Sani?
Nope.
Madame Fortier?
No.
Madame Nassif? No. Ms. Vandeveld?
No.
Monsieur Picard?
No.
Mr. Kent?
Yes.
Monsieur Gourde?
Oui.
Mr. Angus?
Yes.
6-0.
So the motion is rejected again, 6-3. Thank you, everybody. We'll get on with our witnesses today, and I'll just explain a little bit of the plan still. We'll try and get the witness. We only have one, so we still have committee business at the end. It should take us to about 5 to get everything done, being that we only have one witness. So go ahead, Mr. Kelsey, for 10 minutes.
Thank you to the chair. Thanks for the explanation earlier. To use Mr. Kent's language, I am an ex-minion of provincial and municipal experience, and so fully understand what's happening before me here, and maybe even expect it a little bit. So no trouble. To the chair and to members of the committee. As the Toronto Region Board of Trade's Vice President of Public Affairs, I'm here on behalf of the board's 13,000 members. And the Board of Trade is now actively engaged in the debate that you're engaged in about Waterfront Toronto's Quayside project and its agreement with Sidewalk Labs. Our overall view, and I want to stress that word, is that we are happy Sidewalk Labs is in Toronto. We believe that investments by large foreign technology firms can play an important and constructive role in building our growing technology economy, even if the scale-up of our outstanding domestic technology sector remains a priority alongside that growth. We believe that the process agreed to by Waterfront Toronto and Sidewalk Labs should proceed, and that any final outcome should be based on the merits or demerits of whatever Sidewalk Labs presents in its development plan as originally intended by the process. We believe tearing up this process in midstream poses reputational risks, trade risks, and legal risks. And there's no cause to take those risks, since there are literally dozens of steps worth of approvals ahead of Sidewalk Labs on this site, leaving plenty of room to negotiate for or act on behalf of public interests as this process develops. That said, the board was not vocal with those arguments for the first several months of this controversy, because our policy team wanted to address an important public policy issue first. There's a big awkward gap in our minds in the regulation of what we call public realm data capture. Sidewalk Labs has made it clear that public realm data capture services would be part of the business that it hopes to deliver at Quayside. We believe as a business organization that this regulatory gap must be filled for everyone's sake. That's why we released a short report called Bibliotech in early January of this year. Our key recommendations were simple. We argued that data regulation related to the Quayside project should be handled by a third-party organization, not the project proponents or participants. We argued that generally, any public realm data collected in the City of Toronto should, by law and regulation, be held by a public data hub or a public data host or trust. We argued that a good potential host for that hub would be the Toronto Public Library, chartered as it is by provincial legislation, and that the library, as an important civic institution, should be empowered to develop recommendations on regulations to govern that hub. Naturally, the Toronto Public Library would be expected to engage other governments, advisors, and stakeholders to reach those recommendations. We didn't expect that they'd be acting alone. Enforcement of those rules should fall within the purview of the Information and Privacy Commissioner of Ontario. We recommended toughening of those rules as appropriate, and that the IPC Commissioner should have authority to investigate breaches of rules of that data hub if needed. Finally, we argued that the Toronto Public Library should model any effort to capture intellectual property value from this data on the approaches used at university and post-secondary tech transfer offices. Revenue should be used to make the hub self-sustaining, even if commercialization of data was limited, as the library suggested it would be under their model if they were to take over as we recommended. And I'm happy to discuss any of our recommendations in Bibliotech and the reasoning behind them at greater length. But suppose Sidewalk Labs actually manages to race through the MIDP approval, negotiate IP concessions with Waterfront Toronto, win desired building code changes for their tall timber construction plans, and run the uncertain gauntlet of development approvals at City Hall. Even if they walk on water, the data regulation issue we called out in January is still waiting on the other side, unless we, and by we I mean all of us in the sense of the larger political community, act to resolve it. If we don't, we'll wish we had soon enough, because the board has seen other examples in government and in business where agencies, actors, firms are already colliding with the same legal issues on projects of their own in situations that have nothing to do with Quayside. This issue needs to be resolved whether Quayside carries on or disappears for some unforeseen reason in the future. And what's politically remarkable to us, and one reason why we drafted this report in the first place, is that there's actually a consensus of sorts here. Sidewalk Labs and its most vocal critics both agree, and let me pause and repeat that. Sidewalk Labs and both of its strongest critics, they both agree that public realm data should be regulated by governments or agencies if Sidewalk is going to commercialize public realm data from sensors at Quayside. Both Sidewalk Labs and its strongest critics agree that public realm data should be held independently by an external authority once collected, be that the government, a trust, or some suitable agency. They agreed on that when we called them both to see where their heads were at in November. They agree on that today, and we agree with both sides on that question. To close, I'll note that data policy is a point of personal and historic interest to me. As a former Queen's Park political advisor, or a minion if that's the language in the House, in 2001 and 2002, I worked with a great team and a great minister, Norm Sterling, for those of you who remember him, to develop a Made in Ontario privacy regime. Those rules were meant to protect the public, but also to provide a competitive, predictable environment to attract technology firms to Ontario. The draft legislation was ultimately abandoned internally months after I'd left the department. I'm happy to elaborate if anyone cares. This Parliament enacted the Personal Information Protection and Electronic Documents Act nearly 20 years ago. And that act is what triggered Ontario's initiative to try and develop Made in Ontario legislation, in turn that was more applicable to Ontario's local and provincial circumstances. And here we are again, facing an incrementally different world with a new regulatory challenge in the form of anonymized and public realm data issues. We know that on the initiative of Councillors Joe Cressy and Paul Ainslie, Toronto City Council has launched an effort to develop its own data policy. Ontario is consulting on a data strategy as we speak, but ultimately the authority that created a broad framework to address these issues in the earliest days of the internet was right here on Parliament Hill. And a national approach may be appropriate now, whether it's to empower libraries or empower municipalities or just to set a common framework for the country to work with, if it leaves room for innovation, if it's balanced, and if it guides local governments and provincial governments, for that matter, without freezing out local preferences as the original federal legislation did. I hope in any questions that I'll have the opportunity to speak to other issues on the Quayside debate. It's a complex one. But I'm sure the primary reason we were invited to join you today is that we've spoken out on the virtue of public realm data regulation. And we've made it clear that the Toronto Region Board of Trade's support for this regulation can be and is a pro-business and a pro-Quayside position just as much as it is a pro-public interest and pro-individual position in terms of protecting the rights of our customers, our citizens, our taxpayers ad infinitum.
Thank you, Mr. Kelsey, and thank you especially for making us smile a little bit. Sometimes work gets pretty serious here, so thanks for the humor. We appreciate it. I'll go up first of all to Mr. Erskine-Smith for 7 minutes.
Thanks very much. And I want to start, so this is in the context of a broader study on digital government and protecting privacy. And so maybe you can be a little bit more specific about some of these key principles of data management and management of public personal information that is to be collected through new sensors and new automation potentially. And when you talk about public realm data regulation, are there key principles that you are looking at that you would suggest this committee recommend with respect to data management?
I'm going to give you an answer that I want to say at the outset is not exhaustive for all of the obvious reasons, but a couple of things that came to mind. The Bibliotech report was probably one of the most entertaining things the board's policy team has done, in that we deliberately collected everybody in our team, which at that point was, I believe, 7 people, and locked them in a room for a couple of weeks, day after day, to say, let's think some of this through. And one thing that's changed relative to the privacy work I was doing and the Ontario government was doing in 2001 and 2002 is, of course, the premise of most privacy legislation around the world and data regulation legislation is that it's based on personal consent. A company can use this data to do whatever it does as long as it's specific about what it's going to do with that data and as long as they obtain your consent. And candidly, I mean, I think the rules around what is and isn't consent have evolved considerably to a point where the market is very happy and very lax to say yes to a lot of requests for consent relative to what we expected in the early 2000s. But nevertheless, the principle of consent is still there if you're downloading an app and that asks you if it can use your data, and you still have a choice to say no. The problem with public realm data is twofold that I think is particularly interesting for you as parliamentarians. And that is, first, it's public. There's no reasonable way to even get, you can try, but inferred consent, which was, a big doctrinal discussion at the time in 2001. Inferred consent is even difficult to get unless you plaster a particular region with signage and so forth. And yet there's very clearly, two of the examples I usually give on this are City of Toronto cases where there'd be a public benefit to them collecting the data that most voters would probably say yes to, but they're not really acting on what their sensors are picking up in terms of traffic cameras along the King Street Pilot on the one hand, and traffic cameras that they're using to study traffic that could also be used to study accident sites and so forth on the other, because they don't know what the rules are.
That's an interesting point, but just, and sorry to cut you off, but don't they all, I mean, you mentioned Toronto City Council is looking at new data policies. I'm curious about this idea because they already engage in this practice to some extent with open data and have standards. When we look at the Red Rocket app, for example, on my phone, when I'm waiting for the bus, I know it's a certain amount of time away. That's a private party that's developed that app, but it's based on open data from the City of Toronto. So this isn't necessarily a new conversation.
No, quite on the contrary. And part of what I'm encouraged by in terms of how fixable it is that it's not new. There's a lot of jurisdictions that are already operating in this, and you've spoken about some of them in testimony that I've read earlier. The challenge just in Canada is that we don't have common standard sets, a common standard of rules, or even a consistent standard of rules between a number of different federal, jurisdictions in the Federation to play by. We've kind of allowed this to roll up on a very specific subset of, if I've got my phone, I'm walking through, I've said yes to my phone company collecting certain amounts of data on me, but what about the interaction between that phone and sensors? Or what about sensors that are picking up my movement through a particular development site? We've spoken to other developers who want to do this with their developments because they believe it's the future and they don't know what the rules are. The public realm piece is the new piece. There's some good scope around how to limit that. There's a lot of complications around where I think the tough work on this will be. We want to allow a lot of that data to be open. When we spoke to the library, they said they wanted to allow a lot of that data to be open because it's public. You're capturing it from the public realm, and so
long as it's not identifiable to a
right, and
individual.
that's the key is to lay down some crystal clear rules around how to remove those identifiers and do so in a way that anticipates worst possible results in those scenarios. And I think part of the reason why this crept up on us is, Canadian federalism has its great points. It has some of its weak points. And the weak point here is this is a very local problem, which is one reason we propose the library deal with it. We're dealing with street corners here. We're not dealing with banks and federal industries.
But am I right to then say, so we've recommended a significant overhaul of both the Privacy Act for government collection of information at the federal level, but also a significant overhaul of PIPEDA. And if there were that significant overhaul, we would be seeing cities' data policies that would have to comply with our federal rules or provincial rules if they were substantially similar. And then just, you'd have your public data, whether it's the library or some other civic data trust, that would make decisions about what to approve, but cognizant of the federal and or provincial rules that govern?
And the original structure of how the federal legislation was implemented in the early 2000s was very much actually a very good case of Canadian federalism in that it set broad standards and all jurisdictions had to comply with those standards, especially with respect to federal interests. And then below that, there was the option at the provincial level, and it would be just as easy to provide that option at the municipal level to say, provided local and prevent.
It's easy though. So this is sort of what I'm driving at. I mean, we have a federated, we have a federal system, and for good reason. It mainly works, although sometimes there are frustrations with different rules, and businesses certainly face frustrations with different rules across provinces. We can see that with interprovincial trade. But if you have significantly different data policies as between Vancouver, Montreal, Toronto, Edmonton, Calgary, Halifax, is that not a potential problem?
I think it depends on what the significant differences are. A jurisdiction might be more inclined to do more in terms of commercializing their data, provided it was consistent with protecting the rights that the federal legislation would protect. An urban jurisdiction that had more to do with that data might be willing to be more aggressive about how much of it captures and processes it for its own or public uses relative to a smaller jurisdiction that didn't have that capacity. So it depends.
Last question, I know I'm running out of time, but just so the idea is cities would be able to make those determinations, but within the context and following the federal and or provincial rules.
We hope they would, and I retreated from partisan politics by being a cities guy for the rest of my career, and around the world, cities are leading a lot of the innovation in a lot of these close to ground technology areas. So my hope, our hope, the board's hope would be that there be enough room in whatever federal legislation or new standards or even guidelines might be created to say, here's the broad ground rules, but here's some room for local governments to, in the spirit of federalism, make their own decisions about what's within their value set in that purview.
Thanks. Thank you, Mr. Smith. Next up, Mr. Kent for 7 minutes.
Thank you, Chair, and thank you, Mr. Kelsey, for appearing. Apologies for the coincidental conflict with committee business. A lot of the concern and a lot of the opposition and a lot of the driving force between the calls now for cancellation of this project have been based on this sort of dance of seven veils that Sidewalk Toronto has been performing. A lot of secret information, a lot of conflict with regards to getting people on the Strategic Advisory Board to sign oaths of confidentiality on even some of the most basic discussions of privacy by design, for example. Anne Kavukian. The Board of Trade, in sort of sitting silently on the sideline, and I know the Board of Trade has been very supportive of Waterfront Toronto over the years and encouraged a responsible development of a magnificent piece of property in downtown Toronto. Was the Board of Trade not concerned as this entire controversy began to unravel, and when the Toronto Star got that leaked information that seemed to suggest that this has been a real estate deal all along, rather than the simple 12-acre Quayside project based on what most of us thought was a magnificent proposal?
I think to try and answer several strands of that as bluntly as possible, and we can follow whatever other strands you want. Part of why I may be more comfortable with this personally, and why the board is this is very much it's a development proposal, it's an innovation proposal, it's a services to development proposal. It's on one level very complicated in that there's a lot of different features that firms can plug in. And the bidders were, after all, asked to do that by Waterfront, to say, look, let's try and use the addition of innovation, civil engineering innovations, IT innovations, and other services to make this development more interesting, more compliant with their own goals in terms of environmental friendliness, affordable housing construction, and so forth. So I think that's part of what's driving that. And we've said that we're supporting Sidewalk going through the process, but we've also said that support isn't unconditional. That ultimately, we can speak to other details of the process that got us here later, but we have a legal agreement that came through a competitive RFP that nobody has yet presented, specific grounds to say.
General challenge.
I'm familiar with that, and I've read the report twice, and we'll get to that. But nobody has yet specifically said there's cause to overturn the legal agreement these two parties have. And as I noted in my preliminary remarks, I look at this as a civic government expert and see there's literally dozens of points of gatekeeping between here and what Sidewalk wants to get to do. So we have concerns. The data piece is the number one concern right off the bat. We made some public comments. Certainly, I spoke to reporters after the release of the, we'll call it the leak for shorthand. And I said, well, I just don't think from the standpoint of how civic government works in the city that model is going to work, but there may be others worth exploring. And we're taking the approach that Sidewalk's legally obliged to and has won the legal right to file a master innovation development plan. So let's judge on the basis of that plan. The Seven Veils routine may be teasing for some and excruciating for others, but you know, for large developments in many cities across this country, having multiple proposals that go through changes to try and deal with public opinion and anticipate regulatory issues is pretty standard, candidly, and it often takes years for a proposal of this size to actually work through the process.
Do you understand the concern that when a company whose fourth quarter profits were $40 billion last year, and the City of Toronto's operating budget for 2019 is less than 14 billion Canadian dollars this year, that one can see the reason for concern, and again heightened by the fact that Sidewalk Toronto's sibling has taken a huge series of reputational and legal hits in the last few years because of business practices that have been found to be unacceptable, particularly in Europe most recently.
With respect to concern, I'll put it this way, that I want to say at every opportunity I get a chance to, that many of Sidewalk's harshest critics are not close friends of mine, but I admire them. I've worked with them. I've, had more than one consecutive drink with them on occasions. And I respect and understand why they're in their debate. I disagree with a lot of their rhetoric. I disagree with the scale of their rhetoric. I believe that there's a lot of room in this process to manage some of the concerns that this committee has spoken about in previous hearings. I think that's the biggest difference, is that there's a lot of room for a positive win from the board's perspective for our economy and our city from Sidewalk's presence. There's also legitimate public policy views. And as we've already done on the data piece, we're quite happy to say, look, if we think there's room to speak out on those things, there's lots of process left for us to have Sidewalk jump through legitimate public policy hoops if they have to, or to have all the various actors who are involved, negotiate through Sidewalk Labs to get the best result for the city and for the country. So understood. There's a lot to watch on this. And that's a challenge, but it's also a byproduct of the complexity, not just of what Sidewalk's proposing, but what Waterfront is asked bidders to do on a complex site that's owned by many parties.
30 seconds.
A bit of time. Just one last question. Has the Board of Trade called for discussions with individual members of council or members of the government from Queen's Park, or Ms. Cavoukian or Mr. Balsillie, for example, for the differing and sort of conflicting points of view?
I mean, by way of example, myself and Jan De Silva, the board's president, had an extensive conversation with Julie DiLorenzo, who was, the other witness scheduled to be here to hear her concerns. We spoke to at least one other individual close to a board member who'd been concerned on those things. We've made an active effort to try and seek out the opposition on this. We haven't spoken to Mr. Balsillie yet, but I've spoken to a few representatives of CCI, which he's very active in. And one thing I want to flag as well. I mean, as a veteran of two governments, it's a legitimate question to say, look, are we as Canadians giving Canadian firms a competitive shot in RFPs? Are we, doing what people used to do with Big Blue in the 1970s, where you would just always go with the safest party, and the safest party happens to be a large American firm in these cases? I think there's a difference between asking those questions, and we've certainly talked to City Hall in the last few weeks to say, let's ask those questions internally on the one hand, and talking about preferential treatment for Canadian firms, which raises trade risks, or chucking out a firm in the middle of an agreement just because it isn't Canadian, which is the stated objective of some of Sidewalk's most vocal critics. So we're saying, look, we can both grow here, and let's watch the margins to make sure that mistakes aren't made.
Thank you, Mr. Kent. And last up, Mr. Angus, 7 minutes.
Thank you, Mr. Chair. Thank you for this. I might be a boy from Northern Ontario, but I spent many, many years in Toronto. And I'm not all that focused on the privacy issue. I think this is probably the most valuable real estate in North America. Would that be an exaggeration?
It's the most valuable real estate that's all in one place that hasn't really been touched by external development. Yeah, I think that's fair.
Because I remember when Liberty Village was a whole bunch of broken down old factories that punk bands like mine used to practice in, and now it's like so hoity-toity. We thought we were at the end of the world when we used to have to go there. Or Gooderham Works. I mean, that was considered the end of civilization. Now it is extremely valuable. So having very few cities have that kind of real estate that hasn't been developed, that is in the exact ideal location. So when I'm looking at this project and I'm thinking the Toronto waterfront is looking at a number of potential operations that could really, really vitalize the city the way the revitalization of the docklands in New York and Brooklyn did. So the question is, was it for 12 acres or was it for the whole enchilada? That to me is a pretty straightforward question. And we asked Dan Doctorow, and it's like, it's always, he said it's in the RFP. It was always for the whole thing. That's what Toronto waterfront. But I read the RFP and it said it was for 12 acres. So who was it? What was it? Was it 12 acres or was it for the whole thing?
It's I think certainly Waterfront has tried to answer this question from Waterfront's perspective. We're both outsiders on this. The way I have always understood the distinction is that what's unique about the Quayside parcel, as members will know, is that's the piece Waterfront owns and over which they can actually have some control without talking to its constituent shareholders, before they sell it. I understand a lot of the public concern that the land was going to be given away before there was a lot more clarity about that in the plan development agreement. But the plan development agreement says, first off, I think it's important to say this, that the if a deal is executed between the two parties on the basis of Waterfront and all the other parties involved saying yes to the MIDP, that Sidewalk will have to pay fair market value for that land, and that valuation can include the uplift that is already generated by approval, which is often a common problem in municipal sales where they'll give away the land and then rezone it, and that's where you get the value pop. With respect to the rest, our understanding was always that the linkage between the two was that whatever innovations and services that Sidewalk or whoever the winning bidder might have been brought to the Quayside site should also be exportable to other sites in the area. But as you know, that land is balkanized, and for even if they want to, for Sidewalk to access that land, there's layers more of process in terms of getting approval from the three levels of government that own those parcels, and the same city development hell that they've got to go through for Quayside, they've now got to go through for each of those individual sites before they can even access it.
It good advantage if you've got that, because when they said it was always for the whole thing, I look at the RFP and it's strictly for 12 acres. And this is my concern, is that the more questions I ask, I expect just straight up answers. If this is a straight up deal, yet Waterfront Toronto and Dan Doctorow were both adamant this was the second longest RFP, but the Auditor General said it was an extremely short RFP. And I look at the RFP and it looks 36 days. So both Waterfront Toronto and both Sidewalk Labs kept sort of rolling their eyes about that crazy Auditor General's report. Where'd that come from? I mean, when an Auditor General does a report, we as officials pay really close attention. Did you have concerns raised out of the Auditor General's report?
I cracked it open as soon as I could read it. I want to tell you that I think our attitude on this, and let's leave aside all the other issues they raised with Waterfront for the moment, since obviously our focus is on Quayside and you have limited time. With respect to the Quayside bid, I've spent some time criticizing the mayor I worked for publicly for what I very politely called a culture of deal-making in Winnipeg City Hall. The ramifications of that are still spilling forth in the news these days. I've spent a lot of time on variations in RFPs. And I think it's important from my personal perspective and experience, to be clear that I do think there's a significant difference between saying an RFP could have been handled differently and could have been handled one of 6 or 7 different ways from the standpoint of what's best public policy, and actually saying that the RFP had preferential treatment, which the audit does not say. It does say that it says that Sidewalk got more.
They received more than the others.
It says that Sidewalk received more information than the other parties. But on my way here, I stopped for coffee, and it took me 2 minutes to pull up an example from Infrastructure Ontario, which is considered best in class in Canada in terms of running complex P3s. And they give individual bidders on complex bids, because you want them to account for different business models, differential information, and it's not considered preferential treatment. They do it a little differently than Waterfront did in terms of holding confidential meetings with each bidding party to let them ask those questions, so that it's on the record and you know what's in or what's out. And perhaps Waterfront could do that in future to provide a steadier process. But nowhere has anybody said that this RFP, that there's legal grounds to throw it out.
I'm not saying that. I never said that. My question is when we see in the RFP it's for 36 days, the Auditor General says it's extremely short, and then be told it's the second largest one ever. They didn't know what the Auditor General was talking about. That raises questions to me. And so I'm running out of time here, and Ms. DiLorenzo is not here, but she did write a letter to us to contradict Waterfront Toronto, which was the other element that we were told that this had been very well vetted by the real estate committee. And these are developers. These are people who want to make sure that Toronto's getting the best bang for the buck. And she felt it shouldn't have been brought forward because they did not have ample time. So given that it's a controversial project, given that it's Google, which right now I don't think any citizen should be trusting Google on anything till they prove their best interest because of the corporate accountability problems that they've been having, that we should be able to just get really straight answers. And a straight answer is, was there a problem with the real estate review? Yes or no? And she felt there was undue pressure. The Auditor General talked about that. Do you feel that that kind of push to get this thing through deal making causes problems down the road for the legitimacy of this project?
The phrase I used was with reference to City Hall conducting land swaps without proper evaluation of the land swaps, and RFPs that were clearly designed to put certain tangential pieces of land into the mix, to be crystal clear. As I said, I think I've read the audit closely twice. I think there's plenty of legitimate questions that are out there. I wasn't aware that there's still a discrepancy between the auditor's position and Waterfront's position, but I've certainly read the testimony on Waterfront that the RFP was longer. It's always, it will be possible until all of us are dead and then some to improve RFP practices in this country with our different agencies. With respect to Ms. DiLorenzo's concerns about governance, we're trying to look forward, and what we know is we've got supreme confidence in the new chair, Mr. Diamond. We know several of those directors around the table. If there were concerns that they weren't looking at over their shoulder before, you will have seen, as we did without warning, that the board is taking earnest care to say that they're going to be very careful on due diligence when they get an MIDP, which is ultimately going to be the assessment of whether or not Sidewalk has access to Quayside, let alone has any ability to provide services everywhere else on the site. So part of what's funny about this whole issue is that with so many points of decision and gatekeeping ahead of us, if it was a situation where Sidewalk suddenly won exclusive right to do whatever it wanted on dozens of acres and then submit a price to an appraiser, you'd be hearing different testimony from me right now. But instead, what we have is a series of processes where I'm actually, for Sidewalk's sake, more worried about the risk of inertia in terms of they've still got to get through city development approvals. They still have to get through the MIDP. None of those will necessarily be easy given what's transpired in the debate now. And since we share a couple of the critics' concerns in terms of issues like data and so forth, we're at the table watching as well as supporting too. And I hope that makes the process a more positive one for the critics as well as the fans.
Well, Mr. Kelsey, we'd like to thank you for your patience again today and your testimony. We're going to go into some committee business after, just for us. So, again, thanks for coming down today and being with us. Thank you. We'll suspend for about 3 or 4 minutes until the witnesses leave.